Jammu and Kashmir Chief Minister and People's Democratic Party President Mehbooba Mufti has written to the CJI, the Chief Justice of India, that the Supreme Court's recent observations on the inability of the lower judiciary to grant bail in ordinary cases should have been issued as a directive rather than a single column story churned out in newspapers. With this, she has knowingly or unknowingly jumped into an evident ongoing tussle between the Union Law Minister Kiren Rijiju and the Chief Justice of India, CJI Chandrachud, on issues concerning the judiciary, such as whether the Supreme Court should hear bail applications and frivolous PILs when it already has a huge pendency of cases, who should appoint judges, and should the Supreme Court be having long vacations. Namaste, I'm Shreya Agarwal, and I'm back with Citti Media's Current Affairs show. In today's episode of the show, we're going to briefly and in simple words explain the issues being discussed by the Law Minister and the CJI. By the end of this episode, we hope to leave you with just enough information to decide for yourself whether the Supreme Court needs any reforms in its current functioning or it's fine just the way it is. Please join me in welcoming a lawyer and author, Mr. Hemant Batra ji. Namaste, Hemant ji. Welcome to the show.
Thank you. Namaskar.
Namaste. So, Hemant ji, the first thing that we want to know is the Law Minister has recently made this comment that, it's a waste of time, frivolous PILs and bail pleas in the Supreme Court, considering the huge pendency, the backlog of cases. We want to know from you, what are these public interest litigations that he's talking about, and what are bail pleas in law?
Okay. Well, Shreya, first of all, thank you for having me. And definitely the topic which you have raised and which is brewing up in India and even around South Asia as a whole, with regard to the judiciary sort of not coming up to the expectations of the people and the executive and the legislature with regard to disposal of cases and administration of justice, is something which is requiring a lot of attention from different sectors and sources. Now, coming to your question about PILs, let me tell you that there is no codified or universally acceptable description of public interest litigation, PIL, also known in some parts of the world as social action litigation. But generally, it means a kind of litigation which is filed, undertaken, or embarked upon to secure public interest and establishes, rather, I would say, validates the accessibility of justice to socially disadvantaged parties. As a utility, it is perceived as being remedial measures taken on a human rights or quality issue of large public concern. It opens, according to me, a prospect to even clarify, develop, or change the law, basically benefiting the society as a whole. And a very significant ingredient, salient feature of PIL is that it is definitely a relaxation on the traditional rule of locus standi. In India, this concept of PIL was first introduced by Justice P.N. Bhagwati, former Chief Justice of India. In fact, PIL has evolved as a, I would say, key tool through which judicial activism, has thrived and prospered in India. Now, talking, about more than 4 decades ago, let's say, before 1980s, the judiciary and the Supreme Court of India entertained litigation only from the parties which were impacted, affected, aggrieved directly or indirectly by the actions of the respondent. They had to demonstrate direct impact on them. It heard and decided cases only under its original and appellate jurisdictions, beg your pardon. However, the Supreme Court then began permitting the cases on the grounds of public interest litigation, which means that even people who are not directly involved, in those matters, could bring such matters of public interest to the court or to the administration of justice, though it is the court's sole prerogative to entertain or not to entertain PILs. That's their sole prerogative. The whole notion, concept, nature, scope of bail, which you were talking about right at the onset or introduction of this episode, how some people are making noise about people not having been granted bail, etc. Bail is part of the criminal jurisprudence, as you would know, and not only in India, all across the globe. It is a thought through, established principle among all the judicial systems in the world. In law, if I was to talk in a non-technical terms, bail means securing, obtaining release of a person from prison or from legal custody or from judicial custody, who's awaiting trial or an appeal. And obviously, bails are granted on fulfillment of certain conditions, including security. Now, the Criminal Procedure Code 1973 does not define bail, very interestingly. There is no definition of bail given in the CRPC, although the terms bailable offense, non-bailable offense, the categories, etc., have been defined. Now, right to life, Shreya, that's very important. Right to life and personal liberty is an important right granted to all the citizens under Article 21 of the Constitution of India. And it is considered as one of the most precious rights. So under criminal law, there is this provision of granting bail by the courts of law to uphold this fundamental right. And there is even provision of anticipatory bail, which is provided under Section 438, beg your pardon, Section 438 of the CRPC, where if a person has a reason to believe that he may be arrested or detained on accusation of having committed a non-bailable offense, he may apply to the High Court or Session Court for a direction of his release, as and when he is to be arrested. So both, whether we talk about PILs or we talk about bail, they both are integral part of our jurisprudence now.
Correct. So far as PILs are concerned or public interest litigations are concerned, they are basically tools which anyone can use and approach the court. They're basically petitions which anyone can file.
They don't have to demonstrate direct. Yeah, absolutely. Your understanding is absolutely right.
Right. Yeah. So now the issue here is that, while the law minister thinks that bail pleas, even though they deal with such an important aspect of right to life, as you pointed out, and right to liberty of the accused person, but he has said that this is a waste of time because there's already so many cases pending. But the CJI, DY Chandrachud, he has opined that why else are we here if not to hear the cries of these petitioners? What is your take on this, this back and forth?
Yeah. Well, Shreya, we need to appreciate here that the governance operates on three wheels or organs: executive, legislature, and judiciary. Each of these organs have their own set of priorities and targets and pressures of performance and attainment of efficiency goals. I do not think that we should take Law Minister Kiren Rijiju's remarks so literally as labeling bail pleas and PILs as waste of time. What he actually said was that the Supreme Court was taking an extra burden by hearing bail applications and frivolous PILs, public interest litigation petitions. And this remark or stand by the executive is not something new, Shreya. I mean, you'll be sort of surprised to know that it has been consistently there even in the previous regimes. For instance, former Prime Minister Manmohan Singh, way back in 2008, if I correctly remember, in September 2008, had expressed concern over misuse of PILs. My take is that executive has every right to be concerned about the piling up of cases in the judicial segment and even share their opinion, anguish, and advisory. Because at the end of the day, all three organs have to work for the betterment of the nation as a whole. Now, having said that, I would definitely also agree with CJI Justice Chandrachud viewpoint, which is based on the premise and mandate of the law of the land, whether contained in the Constitution of India or statute, or laid down in the historical judicial precedents, to the effect that insofar as bail pleas are concerned, the court cannot and should not afford to ignore even the faintest plea of personal liberty. As you had also put it just a while back, CJI Chandrachud had put it that if we do not act in matters of personal liberty and grant relief, then what are we doing here? The right to personal liberty is a precious and inalienable right recognized by the Constitution. And the judiciary, has emerged as the protector of the fundamental right to life and personal liberty, resting with every citizen. So, and I do agree, Shreya, with the CJI when he says that no case is big enough or small enough for the courts, be it district judiciary, high courts, or the Supreme Court. However, at the same time, the law minister is airing not his personal concerns, mind it, but concerns of the nation or the people as a whole, the Indian citizenry, who are getting frustrated by each passing day, losing hope in getting timely justice. Shreya.
Correct. But so there's also, as a commoner, as lawyers, we appreciate that there's a right to liberty and there's a, right to life under the Constitution.
Yeah,
But as commoners, it sometimes may
yeah,
seem uh, a little problematic that the
yeah,
courts open at
yeah,
even 2 in the morning to hear the accused person's pleas, but they're often not
right,
open, or that
yeah,
same level of accessibility or importance is not given to other petitioners' rights. There's also that
right,
angle. Uh,
yeah.
Moving on.
Well,
So,
there is an
so far
element
as
of subjectivity in administration of justice. See, law can be objective, but when it comes to application of law, be it enforcement or its interpretation or enforcement, it is subjective and it is open to some kind of analysis and criticism. As you had just pointed out, there are definitely some gray areas. There are some areas which definitely can be questioned by the common people.
correct. Uh, Moving on, so far as public interest litigations are concerned, considering that anybody can move, the High Court or the Supreme Court, wherever there is a matter of public interest, and but it's really vague and it's very nebulous. There's no definition as such of
Yeah,
what a public interest litigation is, as you pointed out. So, where do
correct,
you think the line needs to
correct.
be drawn? Because there are also PILs where in the Delhi High Court, somebody moved a PIL saying that this COVID-19 ringtone should not have Amitabh Bachchan's voiceover. So it can just be
Yeah.
really, really nebulous. Where do you think the line needs to be drawn?
Yeah, definitely. I mean, there are some publicity stunts involved. In when people are filing PIL, they're looking for shortcut to hit the media or to be famous and so on and so forth. But PIL is a rule of law declared by the courts. Yet, the person or entity filing such PIL is required to prove to the satisfaction of the court that the petition serves the public interest and it is not a frivolous claim or litigation brought for some monetary gain or as a publicity stunt. They have to satisfy the court. Now, substantial fines have been imposed by the courts. I mean, you would know that on litigants filing frivolous PILs. It is a well settled law that that a litigant who approaches the court must come with clean hands. He cannot evade and take inconsistent positions. The PIL cannot be vague and containing inconsistencies. Further, Shreya, one cannot misuse public interest litigation in business conflicts. That's another area where people have tried to use public interest, or rather misuse, I would say. For instance, a PIL was filed in one of the high courts seeking the closure of some industrial units, stating that the material was harmful to humans and the environment. The High Court dismissed that petition, stating that it was filed at the behest of rival industrial groups who wanted to promote their products as substitutes. And a similar petition was then submitted to the Supreme Court of India, and the plea was dismissed, and the petitioner was imposed with a very, very heavy penalties and fine. The Supreme Court concluded that it was causing industrial imbalance and financial loss to a particular industry through the process of court. I mean, that was the attempt which petitioners were trying to make. The court stated that at that time that it was duty in such circumstances to punish the petitioners under the Contempt of Courts Act. So even punishing them under the Contempt of Courts Act, and the court said that it must ensure that such unscrupulous and undesirable public interest litigation be not instituted in the courts of law, so as to waste the valuable time of the courts, as well as preserve the faith of the public in the justice delivery system. And there are various guidelines also. Supreme Court has laid down in this context. Beg your pardon. And I would say not only guidelines, even filters for that matter, which go to sort of create a sort of a set of parameters under which a PIL has to qualify, and it shouldn't be for achieving some oblique motives on the basis of wild and reckless allegations made by individuals. The credentials, the motive, and the objective of the petitioner, have to be apparently and patently overboard. So there are several guidelines in this context laid down by way of several judicial precedents, and the Supreme Court has been skeptical about a large number of PILs and has advised even the high courts that judiciary has to be extremely careful to see that behind this beautiful veil of public interest and ugly private malice, vested interest and or publicity seeking is not prowling or lurking.
Correct. Now, speaking about the frivolity of some PILs, I think recently the former Chief Justice UU Lalitji, he has also disposed of a lot of PILs which were under his tenure, which were deemed to be
Absolutely.
judged as frivolous by the court, which has also reduced pendency by a good number. Now, speaking of
Right.
pendency of cases in the Supreme Court, how bad is the scenario? Or good?
Well, better I not share I would say it's far away from good, Shreya. Until about 4 months back, there were about 71,000 cases pending before the Supreme Court, out of which 56,000 being civil matters and 15,000 were criminal matters. Out of these cases, Shreya, you'll be surprised to know that nearly 11,000 are awaiting disposal for over 10 years, with 42,000 cases pending for less than 5 years and about 18,000 being between 5 and 10 years. Now, nearly 60 lakh cases, 6 million cases are pending in the 25 high courts across the country. Going by the figures, which are just 6 months old, I mean, these are the figures which are 6 months old, and I'm sure the numbers has risen only. It hasn't come down. The number of backlogs in the subordinate courts is whooping. It's 4.13 crores, 41.3 million cases. Now, if we were to add up the backlogs of all the courts, Shreya, the number rises to approximately 50 million or 5 crore cases. Now, these figures are nothing but devastating. Or if I may say, so these numbers are a blot on the face of rule of law and administration of justice. And let me quote from one of the online sources. In 2018, Niti Aayog had brought out a strategy paper where it was concluded that at the then prevailing rate, beg your pardon, of 2018 of disposal of cases in our courts, it would take more than 324 years to clear the backlog. Can you believe it? 324 years to clear the backlog. So where are we today? If law minister is making noise, I think it's quite justified in that sense. I'm not blaming judiciary even for a moment, but at the same time, I have to say that somebody has to ponder, somebody has to introspect that where things have gone wrong, what reforms have not taken place. And the pendency at that time when Niti Aayog did this 2018 research, it was 29 million cases. Now, cases that had been in courts for more than 30 years, numbered about 66,000 in December 2018. By January 2021, it had risen to more than 60%, to 1 lakh plus cases pending for more than 30 years. So it is definitely a horrific, terrible scenario. Now, what do these facts and statistics demonstrate? I mean, it demonstrates something is seriously wrong, as I just pointed out somewhere, and we must acknowledge it with all honesty, candidness, and magnanimity. Judiciary won't become small if it was to acknowledge that where we all have gone wrong. We won't become small by this sincere confession. Now, having said that, somewhere I feel that judiciary did not reform itself as much as was need of the time and society. The judiciary cannot survive in vacuum. It must change and recast itself, so as to meet the changing norms and values of the society, changing needs of the society. Now, lack of reforms have stifled growth because separation of powers is there in India, and it is not a model which is watertight. So I mean, it has a system of checks and balances as well. So I think somewhere we have missed out something, and which we need to identify.
But 324 years, that's several generations
Yeah,
of
that's
petitioners gone by. So,
yeah,
and then
and
on the other hand, you
you
also
can
have,
Google, and you will be able to find out what I'm telling you. It's Niti Aayog report. I mean, if you will put in 324 years Niti Aayog, and you'll get to know this information. So this is I'm quoting online source, and there are many newspapers who carried out this strategic report as well during that time in 2018.
that's really, really troubling information.
Yes,
And even considering the fact that they say that justice delayed is justice denied. We're taught this throughout law school from the beginning till the end, that justice delayed is justice denied. So, what do you think? What
yes.
kind of reforms can be brought in on an immediate basis to deal with these blocks in the administration of justice?
Right. Well, Shreya, I mean, on this, I can go on and on, but, let me quickly, touch upon the kinds of reforms which can be rapidly introduced in the judicial dispensation. First and foremost, is a reform which has also been sort of very effectively suggested by the Supreme Court, giving all share to them. That is reform about introducing an effective system of ADR, alternative dispute resolution. And I'm not talking about here arbitration. I'm talking about conciliatory mediation process. Before filing any dispute or case in a court of law or tribunal, one must mandatorily make a professional and legitimate and authentic endeavor to resolve a conflict or dispute uh, amicably by mediation. In many developed countries, Shreya, you would know that the lawyer who files the case must sign a declaration with the case as a prerequisite that he or she had made all possible efforts to resolve and settle the said disputes before filing the case. And the lawyer can be reprimanded if the declaration is found to be false or misleading. Now, plea bargaining is second reform which I'm suggesting. That will need to be popularized in India and encouraged. It will have to be incentivized as well. That if you take plea
So,
bargaining,
what
you will
exactly
get
is plea bargaining? Just for the benefit of our
plea bargaining.
viewers.
Yeah, yeah. Plea bargaining is where the accused or the respondent or the defendant, in a criminal case, I'm talking in context of a criminal case, because most of the heavy litigation which is pending in India involves government. So what happens is that in plea bargaining, the government gives you a chance at the stage of investigation and at the stage of filing first motion, that if you want, you can plead guilty. And if you will plead guilty, we will not we will suggest to the judge that you should be not punished as per the strict guidelines contained in a particular section. We could request the judge for being lenient. So, for instance, for a particular offense, the punishment prescribed is 10 years imprisonment. Now, if a person comes forward and pleads guilty, and again, pleading guilty is not getting into the facts, and it does not affect your future or in any which way. You're not acknowledging the guilt yet acknowledging the guilt. So it's a very unique methodology where you are saying that, okay, I don't want to go through the whole rut of judicial process, engaging lawyers, fighting the case and appeals for so many years. I'm willing to accept what you are saying. Now, there is a likelihood that instead of 10 years, he'll go behind bars for 3 years or 4 years. So he is taking that as an incentive, because if he was to lose the case, he can go inside for 10 years. But whereas if he pleads guilty, he enters into negotiation with the government, with the prosecutors. He's just going inside for 3 years. So it is both ways. Both the parties go happy at the end, because state is not required to go through the tedious process of trial and building up cases, and it also avoids cost to the treasury, because at the end of the day it involves cost and time. And for the litigant also, it cuts short the time and it cuts short the punishment. Now, you'll be amazed to know that in Canada, it appears that about 90% of criminal cases are resolved through acceptance of guilt. 90% of the cases. Many of these pleas are direct outcome of successful plea negotiations between the Crown and the Defence Council. In UK, I understand that these figures are between 70 to 80%. In Australia, it's about 80 to 85%. The conviction rate via plea bargaining in the United States of America is as high as 90%, whereas in India, you'll be shocked, it's not even close to 10%. So which means 90% of the cases are unnecessarily hanging in the courts of law. So it is very important that the accused, the parties, the private parties are educated, orientation is carried on or carried forward, and the judges also give substantial time for plea bargain, so that parties
Maybe
could
I
take
guess in
advantage.
India they don't, so sorry to interrupt, but maybe in India they don't accept guilt because they know that the case is going to go on for so long that might as well just let it be, just let it hang.
Yeah, that's true. I mean, because that's the general perception that it doesn't matter. By the time I will even die, my case is decided. So I'll be absolutely free and I'll enjoy liberty. And as and when the case gets decided, by that time I would be in my end of my life or nearing the end of my life. So And that
Yeah, so
time,
there's also abuse of the rights of the accused that we
yes.
uphold, the judiciary upholds so dearly, that the rights of the accused, the liberty of the accused, but there's so much abuse as well of that. Moving on to the next question, sir, the $1 million
Yeah,
question, that in light of this whole
yeah.
discussion, do you think that we need more judges? And does the process of appointment of judges, does that need to change? Uh, Basically, there is one system in which judges appoint judges. Simply speaking, in very
Mhm.
simple terms, layman terms, there's one system in which judges appoint judges, and there's another system in which the government ends up appointing judges. So, what are the pros and
Mhm.
cons of both?
Very interesting question, Shreya. As you know, there are 25 high courts in India. The number of total judges sanctioned in these high courts are 1,108, of which 836 judges are permanent and remaining 270 something are additional judges. Now, as of 2nd January 2023, as of 2nd January 2023, 339 of these seats are vacant, which means about 30% of vacancies are there as of now in the high courts. There are currently six vacancies, or about six vacancies in the Supreme Court, and its sanction strength is 34, and I think there are 28 judges as of now, uh, if I'm not mistaken. So there are, you know, there are vacancies in Supreme Court as well. And if I was to talk about subordinate courts, the sanction strength is about 25,000 judges. To be precise, I think it's 24,631, and of which there are more than 5,000 vacancies. Now, under the present Collegium system, the Chief Justice of India, along with four senior most Supreme Court judges, recommends the appointment and transfers of judges, as you know. And in High Court Collegium, there is it's led by the incumbent Chief Justice, and there are two senior most judges who are part of the Collegium. Now, the Collegium system is, Shreya, very important to note for your audience. The Collegium system is not entrenched in the Constitution. The Constitution does not provide for this collegium system. Rather, it has evolved through the judgments of the Supreme Court. In this structure, the government's role is minimal, is very restricted in this collegium system. The government's role is purely getting an inquiry conducted by the Intelligence Bureau, IB, if a lawyer is to be elevated as a judge or uh, in the High Court or Supreme Court. And the government can also bring up some concerns seeking explanations regarding collegium's choices. But if collegium reiterates the same names and sends it back to the government, then under the Constitution bench judgments, the government is bound to appoint those names or those choices. So government has no role to play, or I would say very minimal role to play. Now, there is a school of thought, Shreya, which believes that this collegium mechanism lacks transparency, as it is not formally official process, or there is no secretariat. It is a closed door secretive affair with no background material available regarding how decisions are made. That is why the government had brought about this 99th amendment of the Constitution, where NJAC or NJAC Act was passed with regard to National Judicial Appointment Commission, was brought about, comprising of uh, people representing different interests. For instance, Chief Justice of India was to chair the NJAC. Then there was ex officio chairman, two senior most judges, ex officio chairman being the Chief Justice, two Supreme Court judges. Then law minister was supposed to be part of that NJAC. And then there were eminent persons from civil society, one to be nominated by the committee comprising of CJI, Prime Minister, and leader of opposition, and then one to be nominated by the SC, ST, OBC community, and so on and so forth. So it was very well represented in JAC. However, the Supreme Court struck down that law way back in October 2015. So I would say, in conclusion to your question, that some reforms may be required where the Supreme Court Collegium could continue, but with little more transparency, and perhaps have more closer coordination with the Prime Minister, Law Minister, and leader of the opposition. So consensus will bring about better candidates and lesser bottlenecks in appointment. And we definitely need no vacancies with that kind of backlog. And again, I also think that this whole participation of all segments will not disturb the independence of judiciary, as is being aired by many, that look, you're trying to interfere with the independence of judiciary. No, not at all. It will not disturb independence of judiciary, because you can have sufficient checks and balances. And this will ensure, Shreya, that instead of fighting for justice, people will start fighting against justice, against injustice, beg your pardon. Instead of fighting for justice, they will start fighting against injustice. But as of now, people are just fighting for justice, not against injustice.
Correct. So just playing the devil's advocate here. So there is also, there's a school of thought which says they say that the government of India is the petitioner with the largest number of cases pending. So if the government
Right.
starts to have any say in the appointment of judges, then wouldn't there be any conflict of interest? Number one. And number two, there is also some people who say that in every other industry, if you have a look at what's happening, how appointments are made, then one would see that actors appoint actors, or the producers appoint actors who have enough knowledge about the field, or teachers appoint teachers, or lawyers appoint lawyers. Then why can't judges appoint judges? Anyhow,
Yeah.
it's been a really rich discussion, and thank you so much for taking time out to join us. And we hope to see you again sometime soon on the show.
Thank you, Shreya. Thank you so much. And this topic is such a topic that where any window of time is inadequate. We can go on, and I'm sure we'll have another round of discussion to deliberate on this issue.
We will.
Thank
Thank you
you.
so much, sir. Thank you.
Thank you.
Namaste.
Namaskar.
Please remember to subscribe to us and switch on the notifications for this channel. For our other social media links, more content, and to support our work, please visit citti.net. Dhanyavad. Namaskar.